Thank you. Please be seated. Good morning. We're here for oral argument in case number CACV 180708, Specialty versus Meritage. These proceedings are being video and audio recorded, so we ask counsel to please identify yourselves and your clients at the beginning of your argument. Each side will have 20 minutes. Appellant's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal if desired. Also, we have read the briefs and we have discussed this case in conference. Counsel, you may proceed.
May it please the court, my name is David Williams. I'm counsel for specialty companies, and with me is Angelica Dobler, a law clerk with my office, who also just passed the bar on Friday. I would like to reserve 5 minutes at the conclusion of this. To begin with, Your Honors, this case really boils down to what I believe are three direct points, which is what claim did specialty assert, when did that claim accrue, and what is the applicable statute of limitations? With respect to what claim specialty asserted in this case, in the second amended complaint, we were clear that we were seeking to assert an action on a judgment to make Meritage liable as the parent company for the original judgment that was entered against its subsidiary company in November of 2011 via a theory of alter ego liability. Not necessarily alter ego as a standalone claim, but as an action to enforce the earlier obtained judgment.
Can I ask you a question, counsel?
Yes,
and
sir.
that would be, why didn't you just bring Meritage in the beginning when you filed the first claim?
It certainly was an option, Your Honor, but I think more directly is, frankly, the action on a judgment is different than the underlying claim, and they're two separate issues.
But there's nothing that would have precluded you from bringing that in your original action, correct?
Certainly, there's nothing that would have precluded us from doing that. In fact, the leak case out of California cited in the reply brief makes it clear that you could do either or, that in some instances, if you're going to hold the parent company responsible for the debts and obligations of the subsidiary, you bring them in the same action. But also California in that case, recognizing the exact theory that I'm asserting here, indicated that you can bring a subsequent action on a judgment to enforce that judgment against the parent company.
Isn't it a better practice to do it in the original action, then we don't get where we are today with?
Well, obviously prudence would certainly support that, but there's also case law and legal authority that shows that you can do it the way that we've articulated, which is bringing an action on a judgment to enforce that judgment. And there's a breadth of legal authority, and the 5 points case that was issued by Judge Teelborg in the U.S. District Court. And I understand that's not binding authority on this court, but it's certainly persuasive authority to get to the point that an action on a judgment was recognized, and that action on a judgment accrues after the original judgment is entered. The other reason, Your Honor, to address why prudence may not have dictated that is this court has not addressed, and the Arizona Supreme Court has not addressed, what exactly an alter ego claim is. There is case law in other jurisdictions that says an alter ego theory is not an independent cause of action. It is a remedy, like an injunction.
So then it's your position that as long as the judgment creditor renews its judgment, it can bring a piercing claim anytime in the future?
That is certainly one way of getting to it, because there's a time limitation built into 1551, which is the renewal component. Now, granted, other states
but it can be renewed more than once.
That is true.
So there's really no time component.
And that's one of the differences that Arizona has from other states that have recognized these claims is that, for instance, New York, the Pasquale case, has a 20-year statute of limitations. Other states have usually a 10-year statute of limitations for an action on a judgment. Now, frankly, the most direct path to reversal of the trial court focuses on the three issues that I raised a minute ago, which is if the court recognizes that this is an action on a judgment and that action on a judgment accrues after the original judgment is entered, the court can look at 12.550, which is the 4-year statute of limitations, which, Your Honor, addresses that component that you just addressed, which is an open-ended question of when these claims could go on forever. And it's an argument that certainly was raised by Meritage's counsel to the trial court. Both parties agree that as a fallback, if 12.548 doesn't apply, i.e. a contract action, which we claim it isn't, or 12-15-51, which is what we have asserted both before the trial court. Both sides agree that the fallback would be the 4-year statute of limitations, which then, Your Honor, addresses the concern that you raised, which is that it's an open-ended invitation with no limitation. That's why 12-550 would also be an alternate basis for reversal of the trial court. Let me tell you what this case isn't. Well, first of all, let me back up for a moment, because the action on a judgment rule is recognized in authority. That's the associated aviation case that was cited, along with the Friedman case that was cited, that both this court and the Supreme Court have recognized that claim. What this claim isn't, it's not a contract claim. The trial court focused exclusively that this was a contract action, but that's not what this was. We haven't pled, Specialty never pled this as a contract claim. The underlying lawsuit between G&K and Maricopa Lakes, that was a contract action, and the merits of that were frankly conclusively determined when the default judgment was entered against Maricopa Lakes. If this case were to be reversed and sent back to the trial court, the sole issues before the trial court and ultimately possibly a jury is Meritage the alter ego of Maricopa Lakes? And there are two elements on an alter ego claim. It's, do you follow corporate formalities, and do you abuse the corporate form as a fraud? Those are the issues, which are separate duties than a contract. And so you can't say that an alter ego claim is the same thing as a contract action, unless you're essentially going to merge them into one claim, which that's just not supported in case law. Now, the Arizona case law that has interpreted alter ego theory in the past has never conclusively determined or made any pronouncement of law in this state that I'm aware of that an alter ego claim is an independent theory of liability. There are other states that have held that alter ego theory is a remedial theory, usually brought in conjunction with another claim, but it's not an independent claim similar to an injunction or respondeat superior. They're derivative theories of liability. And therefore, because the alter ego claim in and of itself has independent duties separate from the contract, 12-548 doesn't apply. It's not a contract action. No matter how many.
If you had named them as an indispensable party, if you're acknowledging that you could have brought them in, then the statute of limitation that is applicable is the contract statute of limitations. It doesn't seem unreasonable to suggest that that's, if you're looking at it as you were on notice, everyone seems to have been aware of the elements that would have permitted an alter ego claim, piercing the corporate veil, or whatever, however you want to couch it. If it could have been done during the initial trial, then it would have been done within the statute of limitations for the contract claim, presumably. Isn't that their argument?
That is their argument, and here's the reason why they're off base on that, or why it doesn't get you across the finish line, is because you still have to then assume that the alter ego claim is an independent theory of liability, and you have to say, if it's an independent theory of liability as a separate legal cause of action, then there's this statute of limitations that applies to it. And I don't think you can couch it that way. I think what you have to do is say the alter ego theory of liability is a derivative claim that flows from whatever action is being pled. And here, it's the action on a judgment rule. And that's what we pled, and that's why other courts have recognized alter ego liability within the context of an action on a judgment rule. And all of those cases, starting back with the district court in the 5 Points case, have all said that where you seek to hold the parent company liable for the debts and obligations of the defunct debtor subsidiary, it's an action on a judgment. And that action on a judgment then accrues after the judgment is originally entered, which then addresses the accrual question of when did this claim arise? It arose, the action on a judgment claim would have only arisen when the court entered the original judgment against Maricopa Lakes. Members of the court, I also want to get back to the point that was addressed earlier about what is the applicable statute of limitations. I think I've already addressed for you why I believe 12548 would not apply by virtue of the discussion that this is not a contract action. We don't believe it's a contract action. It doesn't meet the elements of a contract. It would be something separate from, and in order to recognize 12548 as the applicable statute of limitations, you would have to essentially come to the conclusion that an alter ego claim is an independent theory of liability, and then you have to basically say an alter ego claim is a contract action, which they're not. They're just separate theories of liability altogether. The better place where it fits is in one of two places. 12550, which is what I indicated to you a moment ago, is the fallback, which is if you don't take 121551, 12550 gets you there because it establishes a 4-year statute of limitations from the date the action accrued, which would be the date the original judgment was entered against Maricopa Lakes. 121551, however, I believe is also an applicable and frankly more appropriate time limit. Now, there's a question about that was addressed by Judge Catani earlier, which is it just an open-ended statute of limitations? And I don't believe it is because the renewal sets the time limit. Moreover, the breadth of authority in other states recognizing statutes of limitations that apply to an action on a judgment, applying an alter ego theory of liability, go back and enforce their relevant state statutes for enforcement of a judgment. The 5 Points Court, Judge Teelborg in the district court, found that 1551 was the most applicable, in part because of the time limit issues that were raised earlier, that these other persuasive authority from these other jurisdictions supported that, and that the policy behind the statute of limitations wasn't offended because, again, the action on a judgment only accrue after the original judgment was entered, and then you have the time limit built in for the renewal period. I also want to address, in my last few minutes, 2 final points. One is, in Meritage's brief, they asked the court that the court can affirm the trial court's ruling on any other grounds, including the briefing to the trial court on another motion for summary judgment on the merits of whether specialty had properly pled all of the elements to support alter ego liability as a theory. The trial court denied that motion for summary judgment. There's no jurisdictional basis for this court to essentially reverse the denial of summary judgment on that separate motion. I don't necessarily address all the merits of that in our reply brief, but I think the jurisdictional case law is fairly straightforward on that.
Well, we have jurisdiction over this case.
You do have.
Once we have jurisdiction over this case, we can decide any issue before us, can't we?
Well, the case law, the KB Holmes case that was cited by Meritage in their brief basically says, and it's case law that's been kind of runs through the appellate court common law, which is if the court can find a basis for affirming for any basis in the record, the court has the discretion to do that. That particular case, though, dealt with denial of 2 separate motions for summary judgment, granting of 2 different summary judgment motions, not a denial of summary judgment and a granting of summary judgment. What the other case law that's cited in the reply brief is fairly clear that denial of a summary judgment motion is a non-appealable order. The only issues before the court are the granting of summary judgment on the statute of limitations issue. That's the only issue properly before the court on a jurisdictional basis, Your Honor. While yes, the court has jurisdiction over the case, I think its jurisdiction is limited to what issues were before the trial court, which was the granting of Meritage's motion for summary judgment on the statute of limitations defense. I don't think, and frankly, they're asking this court to essentially go back and review the entire record to see whether the case was properly pled to support all the elements of an alter ego theory, which I don't think, frankly, is supported in the case law that we've cited.
But we review these things de novo. We review the grant or deny. We review the granting of a motion for summary judgment de novo, correct?
You do, but Your Honor, I would say that if they wanted to have this court review with a fresh pair of eyes the denial of their other motion, there would have been a cross notice of appeal which wasn't filed. I haven't found any case law that says that when denial of motion A is before the trial court and the motion B is granted and you appeal that, suddenly then the court then looks at the motion B as a basis for affirming the trial court's decision, which I don't think I haven't found any appellate authority on that. The appellate authority I did find, which is cited in the reply brief, is a motion denial of summary judgment is a non-appealable order that has to be specifically either through a special action or at the conclusion of the case. So I don't see that. In my last 30 seconds, I do want to address the attorney's fee issue, which somewhat dovetails with the contract issue earlier. Even if you find that 12548 may apply, this case does not arise out of a contract. I've already indicated to you earlier that the elements of alter ego theory and liability are different than the duties imposed by 1234101 and duties under a contract. And
Sorry, before you
No,
sit
please go
down,
ahead.
and maybe we can give him more time if I ramble on too long, but the rule that you're suggesting, does it create any concern if the plaintiff simply gets a default judgment against parties who don't respond at all? There's no indication that a parent company or some alter ego is even aware of the litigation. The first time they learn about it is there's a motion to renew a judgment, and you're suggesting there's no opportunity to address the merits of a default judgment in that circumstance?
I'm not suggesting that. I don't think the fact that a default judgment is entered, whether it's a judgment that proceeds through a trial, summary judgment, or a default judgment, I don't think it changes the analysis at the end of the day, which is that parent company liable for the obligations of the subsidiary company? There is a mechanism if they want to challenge the default judgment, which would be they can raise it as an affirmative defense before the trial court, which hasn't been done in this case. They could also go back to set aside the underlying judgment, the underlying default judgment under Rule 60C. So there are mechanisms that could be addressed, which I don't believe affects the outcome of the court's analysis on which statute of limitations applies in a broader sense, Your Honor. Thank you.
Thank you. We will add 2 minutes to both sides.
Jim Holland here on behalf of Meritage Homes. What we have here is the court can and should affirm the judgment in Meritage's favor on 2 different grounds, each one independent, each one sufficient. One is that the claim is time barred. The other is that there really wasn't a valid claim at all. As to the fact that the claim is time barred, the fact is that Specialty's claim was subject to a 6-year statute of limitation. The court's concern here is what does the 6-year statute mean, and that always begins and ends, if possible, with just the plain reading of the statute. So let's take a look at ARS 12-548A1. It applies in 2 circumstances: when an obligation is 1, evidenced by, or 2, founded on a contract in writing. That's the question. Do we have here an obligation that is evidenced by or founded on G&K's contract?
Well, doesn't that
with Maricopa
presuppose,
Lakes?
your argument presupposes that we're talking about whether the obligation arose from the contract or whether the obligation arose from the judgment, aren't we?
Well, Your Honor, actually there can be no judgment that would give rise to an obligation unless the obligation actually existed before.
Well, the judgment may be based on the breach of contract claim, but your subject liability would be on the judgment itself through enforcement action, correct?
No. In
Well,
fact,
isn't that what, and I'll refer to as the New York case just because I have a hard time saying the word. The New York case makes clear, I thought, that at least in that jurisdiction, we're talking about 2 separate issues, and that the cause of action here is just the enforcement action on the judgment.
That assumes, basically, first let's start with what the New York case says. The New York case does make a statement. The New York case provides no analysis. And so you're trying to give analysis and support to something that really doesn't have that analysis or support. So let me see if I can't address it real quickly. First of all, to go back to the statute real quick, and then I'll get to New York in just a second. To go back to the statute real quick, that without the evidence of the obligation under this contract, that is, the Specialty was owed a certain amount of money, without that evidence, they have no claim. And that's true whether you want to call it a claim or a legal theory. The fact is, the statute doesn't call it a theory or a claim at all. It calls it an obligation. And so without going to that evidence, without going to it being founded upon, those are the two options, it is founded upon. At its base, everything that Specialty is seeking is for their work in grouted riprap on a construction site. That is, for their construction contract. They then seek to enforce that through G&K, who is hired by Maricopa Lakes for doing construction work out there. At its base, it is founded on, the very foundation of this is all about paying somebody for their construction work under contract.
How about if they filed their action clearly within the statute of limitations, but say 2 months before the statute of limitations is up, they end up getting a judgment, and not until they try to enforce the judgment do they realize that the defendant doesn't have any money to, and there's a possible alter ego claim. I'm not saying that's necessarily the case here, but under that scenario, the statute of limitations for the contract action has now expired. They didn't have any, if they weren't aware that they had an alter ego claim until they tried to enforce the action. Under your theory, they could never bring that alter ego claim. Is that right?
Not at all, Your Honor. In fact, I make that statement in my briefs, and in fact, what you're proposing is based upon a fundamentally flawed premise, and let me get to it. And that is that under Gus Rosenfeld, the Arizona Supreme Court, when it talks about a claim accruing, it says when you know or should know that you've got a claim against that defendant. When can you sue that defendant? Which means that there can be different accrual dates against different defendants. So, in fact, this point is made clear by TR versus Boy Scouts of America. That's 181 Pacific 3rd, 758. Oregon Supreme Court said, quote, "The limitations period begins to run as to each defendant when the plaintiff discovers or reasonable person should have discovered the defendant's causal role. When the facts that should alert a plaintiff to a defendant's role are different for different defendants, the date of accrual may also be different as to each." The same thing is said by the New Jersey Supreme Court.
What's the court's holding in our case? Does it specify a date when the claim accrued against the parent companies, for want of a better term?
You're talking about in this underlying case, the
right.
trial court? Yes. Well, in fact, in this case, we don't really have to get into that wrestling match of when the claim accrued, because the claim accrued 7 years before the action was filed. It accrued in 2008. And it doesn't even matter whether we look at Specialty standing in its own right, or we look at Specialty standing as assignee of G&K. Because Specialty and G&K both had their claims accrue, both knew as of 2008. Specialty actually went to the trouble of filing a registrar of contractors complaint against Meritage for Meritage's non-payment of the amount that Specialty was seeking to be paid, which, again, waterfalls through the G&K contract. They went through the trouble of filing a complaint against Meritage. They clearly knew that they had some sort of claim that they were wanting to assert against Meritage. G&K was more specific. They are the man who
Is that
owned...
different than necessarily if there's no reason to believe that the defendant is insolvent, they're going to be able to collect on that? It seems like you could still file a registrar of contractors complaint that might be something different than this alter ego claim when you realize you can't collect from a particular defendant.
Actually, not under the circumstances of this case. In fact, the ROC dismissed, saying you've got a contract, the contract is not with Meritage. They knew their contract wasn't with Meritage, which means that the only way that they're trying to seek their claim is because they were saying, look, we don't have Maricopa Lakes around to be paying us. We're going to be going after Meritage. They had also made claims, and they had third-party complaint, and they took an assignment of claim as to Maricopa Lakes as well. They went after both. But there's some, let me clear up a couple fundamental principles that need to be understood. First of all, and to make sure that we understand, it doesn't matter, and there is a legion of cases on this. It doesn't matter if there are two different defendants, you don't necessarily have one accrual date. And so they are still fully protected. Any innocent plaintiff who doesn't realize that they're dealing with some sort of a sham in terms of piercing the corporate veil remains protected against some sort of a loss there.
Well, let's assume for the sake of argument that there were two accrual dates for your client, I thought the general rule was if you have two accrual dates on potential claims, you take the one that's the greater.
That is true.
Which in this case would be the enforcement action, wouldn't it?
No, that principle is a correct principle as applied to any specific defendant. It is not, again, this is a more global perspective
Well,
of.
that's what I just asked. So your client theoretically had an accrual date that began running for the breach of contract if there was an alter ego kind of theory, but it also would have an accrual date for the enforcement of the judgment, wouldn't it?
Not for enforcement of the judgment. It has accrual date for a piercing claim. Piercing does not require a judgment. Never has. You can take a look at all of the case law that has ever addressed a piercing claim in Arizona or elsewhere. Judgment is not an element of piercing. In fact, let me address, because what's been spoken of here is this idea of
Does
it's
it
not a
preclude
claim.
it? Does the judgment preclude going forward on piercing thereafter?
No. No. And let me address specifically, because there's no res judicata that can arise. We don't have the parent company or the owner in front of the court. So let me address exactly what piercing does, okay? Piercing is not its own claim. That's true. It's not its own little theory that lives out there either. What piercing is it takes a claim and it expands the scope of people that could be liable. So if you have a contract and you're looking to pierce the corporate veil for a contract, you must prove contract, breach, causation, damages, and the two elements of piercing that would make Meritage now at fault for what Maricopa Lakes was originally the contracting party for. By the same token, if we had a tort claim that we were seeking to pierce the corporate veil on, then the plaintiff would need to prove that there was a duty, there was a breach, there was causation, there was damages, and the two elements that would give them the right to be able to pierce the corporate veil to reach Meritage.
Or can't you just show up with the judgment and then prove the two elements?
No, because the judgment isn't binding against Meritage.
Well, it would be if they could prove the two elements, wouldn't it?
No, not without Meritage having, and that's the restatement of judgments. Restatement of Judgments 57 is a good example of this. Only if the party, the parent, had notice of it and knew or should have known about the claim, and in fact had an opportunity to step in and defend.
Should Meritage have known about the claim, given the structure of the two organizations, Maricopa Lakes and Meritage?
Not at all. In fact, Maricopa Lakes in this instance, they knew if they wanted to assert something against Meritage, Meritage is listed in the New York Stock Exchange. If they want to assert a claim against them, they know how to do it. They certainly did it with the ROC. But when they came to assert their claim against...
But doesn't that go to your second point, that we should be affirming on the fact there was not enough evidence of a piercing claim altogether?
Well, we can certainly address it both.
No, I'm just saying, you're saying, no, there wasn't enough evidence, we didn't have notice, but doesn't that go to your second argument?
Well, it
Versus
also goes...
just the first argument, which is just a matter of law, when does it start to accrue?
The claim starts to accrue as soon as, and this is something that New York was lacking, and every other one of those cases that you referred to earlier was lacking. Something they were lacking.
So everybody got it wrong, is what
Well,
you're saying?
That's true, but not really.
Okay,
They
well,
reached the correct result. They did reach the correct result for the wrong reason. What it comes down to is simply this. They didn't know, in each case, the plaintiff didn't know that they could have had some sort of a piercing claim. They didn't know the facts that gave rise to a piercing claim. And so, in each instance, the court said, look, in this case, we're going to let them continue to pursue. And it turns out that their knowledge of a piercing claim seemed to coincide pretty closely with when the judgment was obtained. And as a result, the court said, hey, you're still seeking to pursue this. Now, the judgment, the court was a little bit slipshod in its language, and then it said that all you're looking to do is seek to enforce the judgment. That's not really what they were looking to do. No piercing claim requires a judgment. What they're looking to do was enforce the underlying obligation against a parent company. And so they needed to prove those the two elements to pierce plus the underlying claim. Now, in those other
cases... It really does sound like you're
cases...
saying semantics when you're saying they're trying to enforce the judgment against the parent company, right? That's what they're trying to do.
They're trying to
And they're
make
trying
the parent...
to do that on a theory of piercing the corporate veil.
In those cases, the parent company was part of the underlying, participated in the case. And so, under the restatement of judgments, can be bound by the judgment that came out. And then it was just a simple matter of, can we pierce? In those cases, that was the situation. That's not our case. And the restatement of judgments, and plenty of case law here in Arizona that otherwise establishes, says you cannot bind a party unless they're a participant in the lawsuit. That's why we name people in lawsuits. Okay, so this is not a situation where they could be bound or brought in. A judgment, when it gets down to it, goes back, the elements of piercing under Gus Rosenfeld, it says when you know or should know that you could have a claim. The question is, when did they know or should have known that there were these facts that gave rise to an allegation of Meritage being liable, of Meritage actually being the parent company that should be found liable? And the question is, when did they know that there might be a unity of interest and that observing the corporate form would create an injustice? Now, as to those elements, we already have the sworn testimony of Greg Hahn, the owner of G&K, G standing for Greg. He testified, he says, I knew all those things. I was never confused. I knew exactly what I was dealing with. It was never a problem. I knew all of the facts that are being asserted here, and it never caused me any confusion. And that's really what the crux of one of these claims goes to. I might also point out, the argument that is being asserted here is not limited to just piercing claims. If in fact this statute 12-551 is to be applied to just enforcing a judgment, it could just as easily be enforced to a respondeat superior situation. You get a judgment against an underlying employee, you then turn around and seek to enforce that judgment against the employer, somebody else that should be paying based upon additional facts. You have the underlying tort, plus one or two extra facts dealing with it was within the course and scope of employment. The same thing could be applying to sureties. The same thing could be applying to indemnitors. And in this situation, what we would be facing is specialty could obtain a judgment. Let's go on ahead and put it, because the reasoning is no different. Let's take a look at an employee-employer situation. Let's say that there was a tort with an employee. They obtain a judgment against an employee who never reports the case. Maybe they're no longer even employed to Meritage. We end up with a renewal of judgment 3, 4, 5 times. 50 years later, they come in with a judgment that's been accruing interest at a phenomenal rate, well beyond the regular standard of what's available. And there is nothing in their arguments that would prevent them from then asserting a claim for respondeat superior. Because what they're saying here is all we're trying to do is enforce that judgment against somebody else who should also be liable, against somebody else who really is the responsible party. That's not the law. It's not the law under 121551.
Isn't alter ego a little bit different than respondeat superior? Isn't that, you're saying this is actually the same party, is they're just using someone else as opposed to respondeat superior? There's kind of an acknowledgement that this is, you're not that person, but you are responsible for that person. That seems a little bit different to me.
Well, if you're going to be assuming the truth of what they're trying to plead, there is that minor difference. But there's nothing in their argument and nothing in 12-1551 and nothing in the New York case or the others that would lead to a different conclusion. What they're trying to do is seek something that is a complete violation of the standard that was applied by the Arizona Supreme Court in Gus Rosenfeld. They're also ignoring the Arizona Supreme Court's analysis of what is this action on a judgment. The Supreme Court, in deciding what is an action on the judgment, was very clear. The only thing that you're seeking to do is you allege, I have a judgment. And the only thing that can be raised as a defense in that situation is the judgment has been satisfied. That's it.
I thought the Supreme Court reserved the issue of whether an alter ego could be an exception to that general rule.
No. The Supreme Court said that it was not going to step in and opine on whether or not a prior Court of Appeals decision was correctly decided.
But isn't that reserving judgment on that issue?
But that Court of Appeals decision was not necessarily addressing a situation with piercing the corporate veil. And more important, that Court of Appeals decision that we're talking about.
Well, I think you're straining it at a point where they haven't resolved the issue. They specifically said, we haven't resolved this issue. We're not going to opine on it. So it's for us to decide in the first instance and then see if they want to opine on it later.
Okay, well, but the truth is, you cannot address the issue, you cannot rule the way that plaintiffs here are asking you to rule without trouncing on what the Supreme Court did say about an action on a judgment. And so while the Supreme Court did not say, we are going to reverse a prior decision, because the fact of the matter is that prior decision was correctly decided as to the actual outcome. Because, and the reason why, is because of the doctrine of Morris, of Damron, of things like that. We had a situation in which it was a surety, an insurance company in this case, was going to be found liable, the insurance company that had defended. And we already have a legion of case law that says that those people are bound by the outcome of the underlying judgment. That's not the situation with our case. And so the Arizona Supreme Court was only opining not on a piercing obligation, but the whole question of, can you reach possibly somebody else, in this case an insurance company that had participated in and defended the underlying case. And as to that, the court said, we're not going to step in and reverse based upon an unrelated issue of whether or not this was an action on the judgment. That's what they reserved judgment on. Never were they ever reserving judgment on whether or not this is a proper case for piercing the corporate veil, or a proper vehicle to be able to pierce the corporate veil. Something that's important to understand is that this will lead to absolute limitless statutes of limitation. There is no limitation on a piercing claim if that's what the court agrees with here. There would at the same time be no limitation, as I say, on suretyship claims, which, by the way, would involve a separate party that would be found liable, like a piercing claim. It would not with regard to a respondeat superior situation. And it's important to note, our legislature has adopted legislation establishing we want limitations. Every case is going to have a limitation. And if there isn't any other limitation that applies, then we're going to apply the 4-year catch-all limitation. Now, that is in addition to 12-1551. Every judgment, it doesn't matter whether it's on defamation, which has a 1-year limitation, whether it's on going for a deficiency action, which has a 90-day limitation, whether it's for an eviction action, which has a 10-year limitation. Doesn't matter. You get a judgment, it's only good for 10 years until it's renewed. There is nothing to say that 12-1551 is to apply to everybody else's claims out there, and then all of a sudden, somehow this piercing claim seems to have gotten past all other statutes of limitation, all other statutes of repose, and is able to come in and be treated just as if it's just an action on a judgment. It is not. They admit that they could have asserted a claim, they chose not to. And in fact, this does violence to some of the underlying policies of Rule 15. Rule 15 establishes when can a complaint relate back when the statute of limitation has already lapsed. They can't satisfy that test. It violates Rule 60, which deals with when can you end up amending a judgment to be able to bring in another party in this instance. There are all kinds of other areas of law that are being implicated by this, every one of them established under Arizona law, and every one of them being offended by the argument that Specialty is making here today. I see that I have very limited time. Is there, if there's any other questions?
No, thank you, counsel.
Members of the court, are you ready?
Yes.
I'll readdress what Mr. Holland said, but let me sort of break down for you what I see are 3 different ways for you to resolve this appeal. Number 1, you can affirm the trial court's ruling and find that a theory of alter ego liability arises under 12-548. You can say the trial court got it right. I don't believe that's the way you should go. That's why we're here. The second way you could go is you could say that this is an action on a judgment with a alter ego theory of liability and find that either 12-15-51 applies or 12-550 applies. And I'll get to that in a second, and then reverse the trial court and also reverse the finding on the attorney's fee issue. The other thing you can do, Your Honors, is you can reverse in part and grant, or you can remand and affirm in part and reverse in part. And here's where I'm going with that. One of the issues that was discussed is, what is an alter ego claim? If an alter ego claim is always subject to a 6-year statute of limitations, then it's always going to be a contract claim. What do you get into those situations where an alter ego claim may arise from a tort theory, where you get a judgment and you bring a tort theory within 2 years, but in day 2 year and 16 months, or 2 years and 12 or 11 months, you find out now there's a basis for alter ego liability. How do you enforce that? It's outside of the 2-year statute of limitations for a tort claim. And so therefore, you sort of have this alter ego theory kind of out there flapping in the wind. The other way you could address this is you could simply say that an alter ego theory of liability is simply subject to a 4-year statute of limitations in 12-550, and you can find that there's evidence in the record that the trial court found that the claim arose a long time ago and that it simply accrued under 12-550. If you get there, then that would also mandate reversal of the attorney's fee ruling, because you would have to find that an alter ego claim is distinct from a contract claim and does not arise out of contract, and that 12-340-101 does not apply to an alter ego theory of liability for the reasons that I previously discussed. So I see it, those are 3 ways that you can resolve this appeal. Either remand it, say the trial court got it right, reverse and say that the statute of limitations applicable is either 12-15-51 or 12-550, or reverse in part and affirm in part, which is say the court got it wrong, or say that say this is what the statute of limitations is on an alter ego theory and that it doesn't arise out of contract. With respect to trying to pigeonhole an alter ego theory of liability into 12-548, it creates too much guesswork. Because if I'm a potential plaintiff and I'm trying to bring an alter ego theory of liability, but it arises something out of a non-contract claim, how does 12-548 become the applicable statute of limitations? It doesn't. Or you're always going to have to say that an alter ego theory of liability is basically a derivative theory of liability that flows from the original claim and should have been brought when the original claim was brought. But then you have a problem of what statute of limitations would apply to an alter ego theory of liability when you don't know facts to support that theory of liability at the time you file the original claim, such as a tort claim or a negligence claim or a defamation claim. They would always be subject to a different competing statute of limitations. Which is why I think you can come back to and say that the claim that Specialty brought was a claim for an action on a judgment. And
I'm reading the Arizona Supreme Court's language as a lot more narrowly, that it's just you have a judgment. The judgment hasn't been satisfied. This is just an action to renew the judgment. We're not going to try issues that were never tried before. Liability's been established and we're just renewing the judgment. And what you're asking us to do is obviously much different than that. There's a need for an evidentiary hearing, and under your theory, this evidentiary hearing can happen 20 years down the road. That seems counter to the policy's underlying statute of limitations generally that the opposing counsel was discussing.
And Your Honor, I certainly see that there's a compelling policy basis for that. I don't think it opens up a floodgate of 20-year claims. What I think, and frankly, then that would just simply necessitate the reason for adopting 12-550 as the applicable statute of limitations, even on an action on a judgment. The Friedman case from the Supreme Court did not address, it basically outlined the history of the codification of an action on a judgment rule, which still existed at common law. The codification didn't displace the right to bring an action on a judgment, and the breadth of authority on this, including Fletcher's Cyclopedia, have all said that the exception to the general rule is a non-party can't be bound to an original judgment, except in those cases where the non-party is the parent company of the subsidiary because they become one. They're an indistinguishable entity at that point. And so while I can understand that the Friedman case was essentially a narrow resuscitation of what the codification of 1551 is, I don't think it displaces, as Judge McMurdy indicated, the Supreme Court just hasn't addressed this issue of when does an action on a judgment claim become applicable when you try to hold the parent company liable as the alter ego of the subsidiary. And those situations would be narrow in a sense that the only things you're looking at are do the elements of an alter ego theory liability.
Thank you, counsel.
Thank you.
We're out of
I've had
time.
my day in court. Thank you very much.
Thank you. Counsel, thank you for your arguments. This matter is now under advisement. We will issue a written order in due course. We're at recess now to prepare the courtroom for the next argument.